Okay, I wanted to go over basic obligations of public service, but my last video I ended with conspiracy against rights under color of law, which refers to a federal crime outlined in 18 U.S.C.S. 241, where two or more people conspire to injure, oppress, threaten, or intimidate someone in free exercise of their constitutional rights or because of their exercise of said rights. Okay, statutes informed. Okay, conspiracy against rights, deprivation of rights under the color of law. I was mentioning how easy it was, at least to me, to approve in a court of law a conspiracy against rights under the color of law by citing your attorney for ineffective assistance of counsel, the opposing party, whether it be a state's attorney or prosecuting attorney, or a criminal case, opposing party. I mean, civil case or any other kind of case, opposing party, and the judge for judicial misconduct. It's a three-pronged attack. It's rare that anybody enforces, abide by, or goes by the rules of professional conduct or the code of judicial conduct, which is your right to effective assistance of counsel, guaranteed in the Sixth Amendment of the U.S. Constitution, as well as your state constitution. And effective assistance of counsel is described in the rules and the codes, which are all lawyers and judges' legal obligations in every court of law. Okay, so and in both the rules of the codes, reporting misconduct is mandatory, and failure to report misconduct is misconduct, and it's rare anybody abides by, enforces, or yet alone reports any violations of the rules or the codes, which makes it easy to cite your lawyer for ineffective assistance of counsel, the opposing party or the state's attorney for prosecutorial misconduct, and the judge for judicial misconduct. It was the judge's duty to report your attorney for ineffective assistance of counsel for failure to abide by the rules of professional conduct, the state's attorney for failure to abide by and or enforce the rules of professional conduct, failure to report your attorney for ineffective assistance of counsel, as well as failing to report the judge for judicial misconduct. Everybody's supposed to report each other, and legally themselves as well. And you would have to go over the rules and the codes to know that, which I will go over with you. But let me shoot over to the basic obligations of public service. Okay, we're going to use the U.S. Department of Interior. My other video, I use the Department of Justice. Okay, basic obligations of public service, the foundation of ethical behavior, Executive Order 12674. Thomas Jefferson enunciated the basic principles of public service when a man assumes a public trust. Now, the public trust is referring to the Public Trust Doctrine, which makes the political realm part of the Public Trust Doctrine. When a man assumes a public trust, he should consider himself public property, which everything in the public trust is public property. The sentiment has been expressed by numerous others over time, becoming the familiar principle. Public service is a public trust. To ensure public confidence in the integrity of the federal government, Executive Order 12674, as amended, forms the framework for ethical behavior required and expected of federal employees. As a condition of public service, you are expected to adhere to these fundamental principles of ethical behavior. Remember, failure to abide by basic obligations of public service are ethical violations as well. So you can consider discussing this with the Ethics Commission as well. Public service is a public trust requiring you to place loyalty to the Constitution, the laws, and ethical principles above private gain. You shall not hold financial interests that conflict with contentious performance of duty. You shall not engage in financial transaction using non-public government information or allow improper use of such information to further any private interest. You shall not accept, pursuant to such reasonable expectations as provided by regulation, solicit or accept any gift or other item of monetary value from any person or entity seeking official action from, doing business with, or conducting activities regulated by your agency or whom interests may be substantially affected by the performance or non-performance of your duties. You shall make no unauthorized commitments or promise any kind purported to bind the government. You shall put forth honest effort in the performance of your duties. You shall not engage in outside employment or activities, including seeking or negotiating for employment that conflict with your official government duties and responsibilities. You shall disclose waste, fraud, abuse, and corruption to appropriate authorities. You shall satisfy in good faith your obligations as citizens, including all just financial obligations, especially those such as federal, state, and local taxes that are imposed by law. You shall adhere to laws and regulations to provide equal opportunities to all Americans, regardless of race, religion, color, sex, including pregnancy, parental status, national origin, age, disability, family, medical history, or genetic information, political affiliation, and military service. You shall not use your public office for private gain. You shall act impartially and not give preferential treatment to any private organization or individual. You shall protect and conserve federal property and shall not use it for other than authorized activity. You shall endeavor to avoid any action creating the appearance that you are violating the law. The standards of ethical conduct for employees of executive branch, 5 CFR Part 2635, DOI Supplement Ethical Regulations, Executive Order. Well, basic obligations, you'll find them in every branch of the government. Every branch of the government. Okay, and that is one more quick thing, and that's the Public Trust Doctrine. Okay, the Public Trust Doctrine is a legal principle rooted in Roman law that states the government holds certain natural resources in trust for public's benefit, requiring protection and management for present and future generations. Here are more detailed explanations. Origin of the doctrine's roots trace back to Roman law, where certain natural resources like air, running water, the seas, and its shores were considered common property. Care concept, the Public Trust Doctrine dictates that the government, as trustees, holds certain natural resources in trust for public, ensuring their protection and availability for present and future generations. Public Trust Doctrine. Okay, looking for public trust. We have almost everything on eBay. I don't want it. Okay. Example, in California, the Public Trust Doctrine protects the public's right to use waterways for navigation, fishing, boating, and other orientated activities. Importance: the doctrine is key component in environment law, ensuring that natural resources are managed substantially and are available for public use and enjoyment. Evolution and expansion of the public trust doctrine has evolved over time, and its scope expanding to address changing public needs and emergency environmental challenges and emerging environmental challenge. Judicial role: the public trust doctrine is created, developed, and enforced by the judiciary, with state courts' decisions determining its applicability. Public trust doctrine. People ask, what does the public trust doctrine do? The common law public trust protects sovereign lands such as tide, submerged beds of waterways and benefits use, enjoyment of the public. These lands held in trust by a state of California. Okay, what is a public trust? What example is a public trust? Public trust is created by a large group, i.e. public and large non-profit, NGO, charitable institutions for the general public. What is a public trust doctrine? Magna Carta. Through the Magna Carta, the Great Charter of Freedoms, public rights were further strengthened by the insistence of nobles, the privileged social chances that lowerhead calms which obstructed free navigation be removed from rivers. Let's see, what is beneficiary? Who is a beneficiary of the public trust? Unlike a private trust, a public trust does not need to have definite beneficiaries. The reason why a public trust does not need to have definite beneficiaries: it is a public trust, may be enforced by the state's attorney general on behalf of the public. What qualifies you for public trust clearance? Why is a public trust important? Public trust is important. Public trust is a pillar of democracy, fostering debate and participation in currency, compliance with the law, and facilitating reform. So remember, I told you the legal system is part of the public trust. Is a Magna Carta a right? Reissues of Magna Carta enforcements a right of freedom. It gave the people and the right to limit the power of the government. The legacy of the Magna Carta is seen not only in English law but throughout the world, often known as the rule of law. The Magna Carta gave us the rule of law, and the rule of law was established to abolish qualified immunity. How to obtain a public trust? Is a public office a public trust? The phrase public office is a public trust signifies those in public office hold their position and power for the benefit of the people, not for personal gain, and are accountable to the public. Here are more detailed explanations. The concept and phrases that public officials are entrusted with power by the people and must use that power solely for the public good, not for personal or private interest. Accountability. Public officials are accountable to the people they serve and must act with integrity, responsibility, and efficiency. Ethical conduct. Public service requires loyalty to the Constitution, laws of ethical principles, and placing them above personal gain. Public trust. The phrase underscores the importance of maintaining public trust in government and its officials. Examples: Thomas Jefferson. He famously stated that a man assumes a public trust, he should consider himself public property. If you're a politician, you're public property. If you're a lawyer or a judge, you're public property. If you're in the service, in the military, no matter what branch, you're public property. If you wear a badge, you're public property. You are part of the public trust. Constitution provisions. Many constitutions, like the Philippine Constitution, explicitly state that public office is a public trust. Ethical guidelines. Public service is a public trust, requiring employees to place loyalty to the Constitution. Okay, the public trust. Why is public doctrine important? The public doctrine creates a set of rights and responsibilities with regard to certain natural resource common, obligating the state to manage them and the trust for the public. Like Yellowstone, all these national parks. Remember, those are the public trust. And what does it say? Obligated state to manage them and trust for the public. What is betrayal of the public trust? And the term betrayal of the public trust, as explained in Commissioner Romola, is a character phrase to include all acts which are not punishable by statutes as penal officers, but nonetheless render them officer unfit to continue in office. So any betrayal of public trust is unfit to continue in public office at the very least. But remember, violating the oath of office is punishable by fines, removal from public office, and incarceration. What happens when citizens lose faith in the government? I think we all know that. Declining trust in the government turns to lead to less positive evaluations of Congress and reduced support for government action to address a range of domestic policy concerns. What is the Fifth Amendment of the Magna Carta? The Fifth and 14th Amendments of the Constitution guarantees that no person shall be deprived of life, liberty, or property without due process of law. Okay, you have no due process if you didn't get a fair trial. You didn't get a fair trial if you didn't have effective assistance of counsel. And you didn't have effective assistance of counsel because your lawyer didn't even go over what the rules of professional conduct with you, yet alone abide by them. Okay, incorporate with the model rule that English and American lawyers associate most closely with the Magna Carta for centuries. Okay, so remember that. Start with the rules of professional conduct and you'll find out exactly what you're being deprived of. Okay, this is going on 20 minutes. For the purpose of impeachment, culpable violation of the Constitution is defined as deliberately and wrongful breach of the Constitution. Further, violation of the Constitution made unintentionally in good faith and mere mistakes is proper construction of the Constitution does not constitute an impeachable. But consistent blatant violations of the Constitution is impeachable. See, it says, further violation of the Constitution made unintentionally, in good faith, and mere mistakes in the proper construction of the Constitution does not constitute impeachable. Okay? In good faith, mere mistakes, not intentional, deliberately violating the Constitution. Is the president a public servant? The winners of an election are called public servants, and their job is to help make and carry out. While in office of the United States, we hold elections of many public offices. The people we elect for president, senators, and representatives are public servants and work for the federal government. Some states such as Hawaii, Illinois, and Florida have amended portions of their state constitution to include the Public Trust Doctrine. As the court noted in Illinois Central, a state may convey titles to submerged lands in the conveyance inconsistent with the Public Trust Doctrine. Okay, that's 22 minutes. I'm going to cut this one short. Just some more I thought we should go over. Okay, the Public Trust Doctrine. Okay, thank you and good night.